Hey, it's Jordan with Status Coup. Obviously, the major focus as far as the Supreme Court has been just the disastrous overturning of Roe v. Wade, which will be a key issue in the midterms in a few weeks. But right now, the Supreme Court is considering a ruling that could potentially crush workers' rights to strike and really set back the momentum we've had over the last few years. We've seen Striketober the last two Octobers, workers going on strike, of course, union drives, and the Supreme Court now is weighing a case that could really make it damn near impossible for workers to successfully go on strike. Let me give you the details. U.S. Supreme Court poised to give companies new powers to sue workers who go on strike. The U.S. Supreme Court appears set to deliver on another long-standing conservative political policy goal in its first major labor law case this term, with a ruling that could hobble workers' rights to strike amid a resurgence of workers organizing and a cost of living crisis. The justices decided on October 4th to consider whether businesses can sue unions in state court for the economic consequences of strikes and other employee protests, like spoiled products. That sort of labor dispute is a special category of legal action that the National Labor Relations Board has maintained original exclusive jurisdiction over for nearly 65 years. Under Supreme Court precedent dating back to 1959, the right to strike, including the attendant financial harms, is protected by the NLRB, National Labor Relations Act. The statute responded to a turbulent history in U.S. labor relations, including violent suppression of workers by corporations and the government. It essentially erected a national structure to equalize the tremendous power imbalance between employers and employees, primarily by making worker organizing, collective bargaining, and strikes legally protected. That said, the right isn't without limitations. Conduct clearly outside of the scope of a peaceful work stoppage can lose the Act's protection, and workers are required to take reasonable precautions to protect employers' property. The dispute the Supreme Court is currently weighing arose from a strike by Teamsters Local 174, a union of truck drivers for Glacier Northwest Inc. in Washington State, which does business as Cal Portland. The company bills itself as the largest producer of building materials in the Western United States. Lawyers for Glacier didn't respond to requests for comment. Representatives for Local 174 didn't comment. The petition, backed by corporate groups seeking new and potentially expansive powers to recoup money from unions for financial harms incidental to labor activity. It's also supported by conservative groups like the Landmark Legal Foundation, one of the leading organizations behind the school choice movement for expanding religious education, and an opponent of teachers' unions since the 90s. The question in the case portends an unprecedented ruling that could expose unions to costly litigation for previously routine activities, blunting the most powerful bargaining tool for improving workers' pay and benefits during a time of significant labor strife. There have been at least 316 strikes so far in 2022, up from 257 in 2021. So there's already, what is that? Nearly 75 more strikes this year, and we still have a few months left. I want to give you a little bit more information specifically on the case that has been brought before the Supreme Court that they're weighing right now. This is from Slate. In the midst of all this labor action, the court earlier this month agreed to hear a case asking whether workers should have to face crippling lawsuits if they exercise their right to strike. Glacier Northwest Inc., First International Brotherhood of Teamsters, Local Union 174. Given the court's majority's recent history of extreme hostility to workers' exercise of collective power, this development is very concerning. Everyone who cares about workers' rights should be paying close attention. Glacier is a Washington corporation that sells and delivers concrete, which hardens quickly if it is not constantly mixed. After the prior collective bargaining agreement between the company and its workers expired, and amid negotiations for a new contract, more than 40 Glacier workers went on strike. when the strike began, all the striking drivers left their trucks running so the cement in them wouldn't dry out. Turning off the ignition would not only have rendered the cement unusable, but also permanently damage the trucks. The company managed to empty the cement out of the trucks, and there was no harm to the vehicles or premises, but the company had made no contingency plans for backup staffing, so it lost money because it had to dispose of the cement itself. Glacier sued the union in state court for damages based on the loss of cement. So essentially, in that case, the company had no backup plan if workers went on strike, so they didn't have workers to deal with the cement so that it would be usable, and they then want to sue the workers for loss of, I guess, income or profit. Well, that could basically be applied to name your strike. The John Deere workers that I went on the road to cover last year as they went on strike in Iowa, Illinois, and other parts of the country. I mean, if the Supreme Court rules in favor of this company in Washington State, it opens up the Pandora's box for companies like John Deere to sue workers who went on strike for loss of income if they didn't have backup staffing or prepare for backup staffing to drive the forklifts, move parts, whatever the normal daily routine of business is. I mean, you could apply it across the board. I mean, definitely Amazon. They're currently obviously in full union busting mode to try and prevent any of the warehouses from unionizing. But we have started to see workers doing walkouts at Amazon. Going in Atlanta, they did a walkout. Other parts on other Amazon warehouses on Prime Day, they did walkouts. Amazon JFK 8 in Staten Island, who has won the historic victory, but Amazon will not even recognize them. Well, if they go on strike, once they're recognized, can Amazon say, well, we didn't have a backup staffing plan, or workers left their stations, messed up their workstations, which made it so the backup workers that we do have couldn't move products, what they call picking. So we're suing the workers for lost profits. This would be a deterrent to voting to unionize at these warehouses for fear that you could be sued if you go on strike as one of the workers. And B, obviously, if going on strike could mean you're going to be bankrupted, because obviously Amazon would be suing the unions and the workers who are on strike, that you could be bankrupted because Amazon's got more money in the world for an army of lawyers. Right now, they're paying tens of millions of dollars to send consultants, i.e. union busting consultants, to warehouses like ALB1, which I just covered in Albany, and other warehouses. I mean, they have all the power, they have all the legal means, and they would be basically suing the workers from going on strike. So this has a chilling effect because workers who are going on strike already are making sacrifices. In most cases, they're potentially losing their health care if they go on strike. Obviously, they're not getting paid. There are strike funds as part of a lot of the major unions that provide striking unionized workers some of their pay, but it's not their complete paycheck. So you're already down health care. You're already getting a partial, if you're lucky, half your paycheck if you're on strike. And then, John Deere, Amazon, whatever the company might be, they might sue for lost income. And honestly, 6-3 Supreme Court, I'm pretty sure every conservative would vote for this on the Supreme Court, which I don't really know how you reverse it if the Supreme Court rules in this favor and rules in favor of basically making it easier for companies to sue workers who go on strike. And also the problem with this is it's a very slippery slope. So when businesses can sue unions in state court for economic consequences of strikes, well, they could say that's a pretty vague and broad category of what the economic consequences are. So that opens up a full Pandora's box of what these companies, again, who have all the money in the world, all the lawyers, can basically make a case that, going on strike for an hour caused them severe economic consequences. What those economic consequences are, well, that would go before state courts, who more and more are stacked with conservative judges. So this is a really, really important development. I don't want to say, compare it, how important it is to other Supreme Court rulings. But I mean, at the end of the day, just look at this chart. If you want to know anything about the importance of unions in this country, as union membership declines, income inequality increases. So this is over the last, almost a century. Look at that red line. That's union membership going drastically down, and that's all the money going to the top 10% as that union rate goes way down. Here's another chart. Rate of U.S. unionization falls to record low. 10.3% of all working Americans were union members in 2019. So the fate of the working class in this country is linked to unions. Also, the ability to strike is linked to unions. Majority of the workers that are going on strike are part of a union. So this is very connected to the union drives and workers going on strike. If the Supreme Court rules to allow companies to basically sue and scare the living shit out of workers to not go on strike, it also is going to be a disincentive for workers to try and unionize, because part of why you unionize is for the ability to go on strike without consequences. There are consequences, but without getting terminated. So we'll stay on this, maybe do an interview with labor experts on the chances of the Supreme Court ruling in favor of the company in this case, which would be devastating for the union movement and the workers movement in this country.